Good morning, everyone.
Good morning.
Good morning.
Morning.
Morning. Good morning.
As everybody gets on, if anybody's having any tech issues, please just raise your hand, send us a text. I don't care what. We'll figure it out. It's always difficult when we switch platforms, but we're in Teams today, so. All right, it is 9 a.m. and I'm going to call this meeting to order. It is the public meeting of the Child Support Guidelines Committee. It is December 9th, 2022. It is 9 a.m. and I am going to do roll call. I do know that we've got a couple of people that are sitting in as proxies for members of the committee. I am going to call the original committee member's name. If you are in as a proxy, please state your name, spell it for the record, and then we'll have a complete record of who you are sitting in for. Let's start with Kathleen Baker.
Yes, Sarah Mollick on behalf of Kathleen Baker. My name is Sarah with an H and last name is Mollick, M-O-L-L-E-C-K, on behalf of Washoe County District Attorney's Office.
Okay, thank you very much. Karen Cliff.
Present.
Assemblywoman Cohen.
Here.
Ellen Crecilius.
I'm here.
April Green. Okay, Melissa Hardy. Dallas Harris. Judge Hoskin.
I am here.
Kathy Kaplan.
I am here on behalf of Lisa.
But you're here. I'm so used to you being on the committee. Yeah, you're here for Lisa. I didn't follow my own rule.
That's okay.
For Lisa Swearingen.
Yes.
Keith, Senator Pickard.
I am here.
Judge Robb.
Present.
Joseph Sanford.
Present.
Judge Shirley. Justice Stiglitz. And myself. So we have a quorum by the skin of our chin. All right, this has been a project getting this meeting going. Just for quick administrative purposes, we're on Teams today because Legislative Council Bureau is unable to assist us with being so close to the session. So give us a moment. If there is any tech issues, it's not gonna be as smooth today, I guess is what I'm saying. Maybe it will, but we'll do our best without them. We're gonna move on the agenda to the public comment. If there's any individuals present that would like to give public comment, you're allowed to do so right now.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time, and then also Miss Green just joined the meeting.
Oh, okay, thank you. Hello, Miss Green.
Monday's okay, just as soon as possible.
We can hear you, Senator.
Sorry.
That's okay.
I guess I clicked the button and then didn't realize I had, so I clicked it again. Sorry about that.
You're fine. We're going to move on in the agenda to the approval of the meeting minutes from September 30th, 2022. Do I have a motion?
So moved.
Senator Pickard is a motion. Do I have a second?
Second.
Joseph Sanford is a second. Any discussion? Assemblywoman Cohen?
Yes. Can the minutes reflect that you are referred to as chair as opposed to Miss, unless you prefer otherwise, and then that I be referred to as assembly member or assemblywoman? But I just want to make sure we're consistent that, you know, for instance, Senator Pickard is referred to as Senator Pickard, and I'm referred to as Miss Cohen, and you're referred to as Ms. Surratt. So I just want titles to be reflected.
Okay, we can do that.
Thank
We
you.
have staff who prepares the minutes for us listening on this call right now, and I'm sure they're taking notes on that.
Thank you.
Any further discussion?
Glad somebody's looking at the details.
Hello?
I'm just happy to have a meeting going. All right.
Yes, hi.
All in favor, state aye.
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 Okay,
Aye.
I'll be here.
Anyone
Thank you.
opposed?
Okay, bye.
All right. Anyone abstaining? All right, motion-
I'm abstaining.
I can't tell who said that. Sorry. Sarah
Sarah
Mullick.
Mullick
Okay,
abstaining on behalf of Kathleen Baker since I was out at the last meeting. Thank you.
Okay. I
And
appreciate
I'm
that. Thank
abstaining
you.
as well. Kim Surratt.
Okay,
Kathy
thank you,
Kaplan.
Ms. Kaplan. Thank you.
Yep.
All right. We will move on to the next agenda item, which is the master document. I don't know that nothing's changed on that since the last meeting, so I'm going to assume it's just that I keep putting it into the agenda so that we see it and we know where we're at with changes. Unless I have anybody else wanting to discuss that document. Hearing nothing, we'll move on. Agenda item number 5, discussion and recommendations on proposed reorganization and language changes to the NAC. This is exhibit number 2, prepared by committee member Joseph Sanford. And there aren't any changes. We just have not voted on these changes yet. And it was for us to sit on, and we have Mr. Sanford with us today. And so I wanted to make sure we were, in the prior meeting, we did not have Mr. Sanford, so in case we need to discuss anything. But any discussion or a motion on his exhibit? Now, I will make one comment on it. The changes that we would be considering are the ones that are in green. The other changes were prior votes, but there have been votes in between that. The purple is from one of the original master documents. So we're not discussing the purple changes, just the green changes.
All right, and then I just have one question, and that has to do with, at the very end, we have 425 XXX. Are we leaving that to LCB to number?
Yes. Well, that was the theory, or my theory.
All right, I'll move to accept the changes as written
In green.
in green.
Okay. And do we have a second?
I'll second. This is Karen.
All right. Thank you, Ms. Cliff. Any further discussion? Okay. All in favor, state aye.
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 Anyone opposed? Anyone abstaining?
Sarah Mullick on behalf of Kathleen Baker abstaining.
Okay. Thank you, Sarah. All right.
And
Motion
just a
passes.
comment, thank you to Joseph Sanford for getting that done. That was yeoman's work, as always.
Thank you.
All right, we are going to move on to agenda item number 6, discussion and recommendations on the proposed language for NAC 425.115 subsection 3 for joint physical custody to change the language to 1/2 of the difference versus the full difference in child support values. This is exhibit number 3 submitted by committee member Senator Pickard. Any discussion, Senator Pickard?
Thank you. Not really. I think we have pounded on this pretty well over the last several meetings. I will just mention that after the last meeting, I did just kind of an informal survey, not that I have any reports to submit, but in talking to opposing counsel in many of my cases over the last month or so, I've asked their opinion on this, and I got universal support because it's an equity issue. So I do think that we will have the bars, or the majority of the bars support in this when we propose it.
I have a comment.
Yes.
This is my second meeting, but I feel strongly about this one. So I want to say that I believe that the proposed calculation to cut the amount in half when it's joint physical custody between parents is basically designed to reduce the child support obligation when there is a significant difference in income between the parents, but at what cost? Because the majority, anecdotally, of family court litigants are working poor people. And this effort to help higher earning parties will be at the expense of Nevada's children. That money, however small it is, pays bills. And these households and children need that money for everyday expenses like gas, rent, living in weeklies, food, school-related fees, sports, everything a person needs to run a household. It's already by definition a one parent household. So this change will be at the expense of the most vulnerable, the people that are earning decent wages who are adversely affected by this, to me, are not the ones, given our practice at Legal Aid, that are at the top of my conscience. I'm thinking about the people who get as little as $300 would now get $150. So I believe that our children, Nevada children, will be adversely impacted if we were to do this. Thank you.
Thank you. Okay, for the record, that was April Green. And Miss Green, can you turn on your camera, please?
Okay, I'm looking pretty bad. I don't know if y'all can handle it.
Okay, I know, but
We
the
don't care.
AG's
It's
office,
okay.
the AG's office prefers that we have our cameras on as committee members.
Okay.
Thank you. I appreciate it. And just for the record, so we have it clean. So Ms. Molick, you're next.
Thank you. On behalf of the Washoe County District Attorney's Office, our proposal would be to remove the half of terminology in the proposal on Exhibit 3 and just simply leave the very last line, which is subject to adjustment pursuant to NAC 425.150. We believe that this proposal is appropriate because persons who are represented by attorneys can argue these adjustment factors to the judge. It gives the judge the discretion to make the proper order in the case. But, you know, typically what we see is pro se's aren't going to argue these adjustment factors. And we believe that there's problems with taking this language and cutting in half, like Ms. Green said, money that children leave. And we believe that children are getting lost in all of this. This is not something that's for the benefit of the parents. Child support is for the benefit of the child. So our proposal is to remove the half of language and simply keep the adjustment factors proposal in Exhibit 3. Thank you.
Thank you, Senator Pickard.
I think Judge Rob was ahead of me.
Oh, were you first, Judge Rob?
I don't really care.
You guys pick.
And Senator Pickard, thank you very much. My comments go back to the very beginning of this committee. The last two speakers have not had the benefit of the discussions that have taken place, and that is unfortunate. So I'm going to replow some ground, and that ground is this. We have been, from the federal government, requested to right size child support obligations. In right sizing an obligation, it is far more likely that that obligation is going to be paid. It's going to be willingly paid, and we are going to spend far less time trying to collect it. In this particular case, this is not a matter of taking money away from children. This is a matter of doing something that should have been done in the first instance. The formula that we have right now is in error, and it is in error in favor of the primary parent. That is, while that is true, it is still an error, and it is still a matter of equity. And it isn't appropriate to ignore a matter of equity because the result is something you feel good about. That really isn't what this committee is here for. And to, in this particular case, deal with an error that is going to help in the long term get child support payments paid is something that I believe is important. And it is an amendment that I support.
Senator Pickard?
Thank you. And what I was going to say is very similar, so I won't hit it twice. But one of the comments that I consistently have heard is that this is a due process and equal treatment question that we think might have some federal implications were the feds even interested in getting that granular, which I don't expect. But to the point, and I think Ms. Malik raises a good point, and that is that these are subject to adjustment. I would just disagree. I think the judges, including the hearing masters in the child support court, do a pretty good job of trying to right size the awards. And so when we're looking at, particularly in Ms. Green's suggestion, because I think she's right, that the majority of people that are locked in at the in the DA's offices are the low-income individuals. People that have money usually resolve these things at the district court level as they're battling over other custody issues. So I think that she's probably right, but we need to rely on the good faith of the hearing masters and the judges in right sizing, which is something that we have been pushing for from the start. So I won't belabor it. I agree with Judge Robb. This was something that should have been done in the first instance, and we skipped over it. So I see this as a correction, not missing the boat as to kids. I really do think that kids are going to be taken care of properly because judges are going to make sure that it happens to the extent they can.
Ms. Cliff?
I just want to say that on behalf of the Clark County District Attorney's Office and someone who has been on the committee since the inception, we are aligned with Legal Aid and Washoe County District Attorney's Office. Thank you.
All right, my comments would be that that position from the DAs and from legal services ignores the fact that we are talking about a person paying child support who has the children in their home 50% of the time, or 60 maybe they're the 60-40 is our split for joint custody, so they could even have the children 60% of the time and be paying so much support that isn't fair, that they can't pay their own bills. They can't put food on the table because their child support is too high. And we see this often where we've got payors in front of us who, during our first, in the inception, if you want to use those words, beginning of our committee, we had guys testifying about this, saying, I've got my kids 50% of the time and I can barely afford my apartment and she's living in a mansion. I think it's craziness to say that the recipient is always the one that can't pay their bills. And I think that attitude of I pay, thus I must be able to pay my bills, no matter what you set my child support at. And despite the fact that I may have my kids 60% of the time and it's still joint custody, is insincere and ignores that they are just as important as the recipients and that they need to pay their bills and they have their children in their home too. Any further comments? Do we have a motion?
Move to approve.
Do I have a second?
Second, this is Judge Robb.
Judge Robb. And the first was Senator Pickard. All in favor, state aye.
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 Okay.
Aye.
Okay. Hold on. Raise hands. I lost track really quick. 1, 2, 3, 4, 5, and myself 6. Okay. And opposed.
Opposed?
Opposed.
Opposed.
Okay. Hands up. 1, 2, Sorry, the technology is not helping me in this. I believe we have 4 opposed. Is that correct? Okay, motion passes. Moving on to agenda item number,
Madam Chair, this is Ryan
Yes.
from the Attorney General's office. It's my fault. There's no item 7. I failed to catch that.
oh.
So let's go right on to 8. Y'all can laugh
Okay.
at it. That's fine.
All right, well, we have a ghost 7. We won't discuss it. And we will move on to agenda item number 8. Discussion and recommendations on conflicting language between NAC 425.160 subsection 1 and 425.160 subsection 2. The obligation termination conflict. Oh, we did not have good English here. Termination, the conflicting language between the 2 paragraphs. Exhibit 4 from committee member Cliff, if you don't mind discussing what you proposed to us.
So I have the sample in the exhibit. I don't know if you guys got a chance to take a look at it, but it just kind of makes the sections similar. I think we discussed it the last session and it's been a minute. I forgot who proposed it, quite frankly. I think I volunteered to change the language, but
Yeah, I think committee member Swearingen, who is Kathy's here for her, Miss Kaplan's here for her today.
yeah.
But she brought up the conflicting language part of it.
So let me see here. Sorry, I'm trying to get the document pulled up.
Is the difference between whether you had joint or 2 children in a household or 1 on the order and when that obligation would end.
Hold on, let me try to
Can you
find
guys
it.
see my screen or no?
Yes.
Okay. I'm not as adept at Teams as I am
Here it
at,
is.
so.
Madam Chair, can you enlarge that at all?
Yeah, I will.
Because I'm
That was
reaching
search, not.
the my arms aren't long enough problem here.
Yeah. Working on it. View. Here we go. Zoom. No, that didn't work. Dynamic. Oh, okay. Is that any better?
It is, thank you.
Okay, it's not quite all on the page, but let's see, right there. Okay, Miss Cliff.
Actually, if you don't mind, I'm going to defer to Kathy on the background and of this proposal. I made the changes, but quite frankly, I would rather just defer as to kind of what the basis was for the change.
Okay.
So on this one, it says if there's only 1 child, it terminates the first month following the date the child reaches 18. But if there's other children on the order, it ends the following day that the child turns 18 or 19, whichever comes first. Graduates or 19, whenever comes first. And so it was just a conflicting language as to when the child actually emancipates and when current support ends. We just wanted to align the 2.
All right, so the proposed change language is the italicized language, right? Which I believe is this part. That's all that's been added or changed. Correct?
I think that's correct. It was just aligning 1 and 2 together.
Okay. Any comments from the committee?
This is
I
Senator
feel
Pickard.
like, oh,
Go
sorry.
ahead, April.
Oh, I was just going to say, I mean, it seemed to make sense to me to do both the month after the birthday.
I was going to say the same thing. This is Keith Pickard.
This is Sarah Malik. I echo that as well. When we're doing the child support orders, if a child graduates in June, for example, then the ongoing changes beginning the next month in July. So this language seems to support that consistency and clean up the current statutory language.
Okay. Do we have a motion to accept the proposed revision?
This is Sarah Malik. I'll move.
Okay, thank you. And a second?
I'll second it, Keith Pickard.
Okay. Senator Pickard, all in favor state aye.
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 Said further discussion. Do we have further discussion? Okay. All in favor state aye.
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 I'm rusty.
Aye.
Anybody opposed? Anyone abstaining? All right, motion passes. All right. So we are now on agenda item number 9. Discuss and approve ideas for future agenda items in the next meeting date and time. Let me give a little bit of administrative comments here. With all of these changes that we have, they'll be incorporated from the votes today. I'll incorporate those into the master document. With everything that's in that document, it will go to DWSS, and they will do their administrative end of it to hold a couple of public hearings before it goes to the legislature for formal drafting and approval there. The likelihood that that happens, though, I think before session is probably not going to happen at all. It will probably not come out as actual changes until after session. So we have a big gap in time now. If we want to hold any additional meetings in between now and then, we need to be cognizant of the fact that we have committee members that are legislators and that we will not have LCB assistants. But does anybody have any agenda items that they feel needs to be addressed or that we must or need to have a meeting right away for? Judge Hoskin.
Yeah, and this came up in a recent CLE that we were doing. There was a Supreme Court case that came down and essentially put a cap or a presumed cap in certain circumstances. That the suggestion was perhaps the committee could clarify that for the appellate courts or codify what they have done. Unfortunately, I don't have that case in front of me to give you the site, but it was a fairly recent case that essentially interpreted, in my view, and I don't know, Senator Pickard, I think you were at that meeting, I don't recall, it was inconsistent with what we had done, or at least our intent. So I'm happy to provide that additional information outside of the meeting so that we can put that on, but I think it's something we probably need to take a look at.
Okay, is it something we just need to create a record on versus an actual edit to the statutes?
I don't know that I want to tell you how the committee should proceed, but I do think we ought to at least consider what it has done and if it has done something different. Certainly, I'm not the committee, but in my mind, it was contrary to what we had anticipated with that language.
Okay. Then if you could bring that to my attention. I'm not sure what case it is. I apologize. I'm not familiar with this situation. So,
Madam Chair, this
Mr.
is
Sanford, yeah.
I believe the case you're speaking of is Matkalak versus Davis, and it's 138 Nevada Advance Opinion 61. send you a copy of that. Or Joy, if she wants to.
That does sound correct.
Okay. Okay, so I can hold a meeting so that we can discuss specifically that case and what we need to do, if anything, as a result of it. And we can do that with another, using Teams and having another meeting just for that purpose. Is there objection to me submitting the changes we have to date without having that discussion so that we can get the other changes moving forward? Okay. Senator Pickard.
Thank you. I was just going to say exactly that. I think it would be wise for us, given how much time it's going to take DWSS during the session to work through the public meetings and all that they are going to have on their plate. I think we should move forward with what we have. But I think Judge Hoskin is spot on. At least I didn't contemplate the cap in the way that the Supreme Court or the Court of Appeals, whichever it was, contemplated it. That's obviously the danger of any legislative body of any type. We can't think of every permutation of interpretation that a judge or an appellate bench might consider. And this is one that I thought we just didn't really think that through from that angle, where it became a cap and we didn't really intend it to be. It was just so that we were, again, trying to right size things. So I think that's actually going to take a little bit of drafting work. I think we're going to have to really work through what the Supreme Court said and come up with language. So I would bifurcate that from what we're doing, the master document up to this point.
Okay. Assemblywoman Cohen.
I'm sorry, I'm looking for that case. I think I wrote down that citation wrong. It's 138, Nevada Advanced Opinions 61, 161?
61.
138 and then 61. Okay, thank you.
I've got it up on my screen, Leslie. This is Keith Pickard. I'll just email it to you.
Ooh, thank you.
Okay. Any additional agenda items? Okay. I will set a meeting after the new year for us to discuss that case. How about that? Because I don't think it's realistic to say we're going to try to squish that in. So we will look at, after the first of the year, I will set a meeting for us to discuss that case. And I'm not hearing any other agenda items, but if before we send out that agenda and we set that meeting, if anybody else has anything that comes up, just send me an email in order to get placed on that agenda. So for now, Ms. Kaplan, I will get that master document to you and Ms. Swearingen to proceed on for the procedures that you need to for DWSS with all the votes that we had. And I believe that is it for that agenda item. Anything else? All right, hearing nothing, we will move on to public comment. If there's anybody on this call or listening that would like to give public comment.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
All right, I am going to adjourn this meeting. Happy holidays to everybody. Happy New Year. Good job, committee. We have another set moving forward. I'm proud of us. I will see everybody after the first of the year, and we will keep moving on. I appreciate everybody. Thank you.
Thank you.
Thank you.
Kim, before you go,
Chair Surratt. And I just got to say, I have thoroughly enjoyed working with you as chair. I look forward to continuing to do so as long as you're willing.
All right. Thank you, everybody.
hi, Kim, can you hear me?
Yes.
This is April. I don't see my initials at the bottom. I'm sure you all know I'm here, but just, I think at the beginning, I heard click to raise your hand or something like that. I just didn't see my initials, just FYI.
Okay, I see your name on the screen.
Oh, you do? Well, maybe it's just on my end. Okay. All right. Thanks a lot. And happy holidays, everybody.
All right, thank you. Bye-bye.
Bye. Thank you.
Bye.